Hello and good evening. Today I'm talking about for those who are on a skilled worker visa route in the UK, and specifically for those who are currently in the UK on with dependents on a graduate visa or on a study visa. The question I get to hear quite a lot is that basically those who are in the UK living with dependents on a graduate visa or on a study visa, what they ask is that in the future, if they get a sponsorship for a job which is classified as a medium skilled job, whether in these circumstances their dependents already in the UK can continue with them on a skilled worker visa route. If you are in the UK with dependents on a graduate visa and now in the future you will find a sponsorship which is classified as a medium skilled role, let's suppose for care worker, then in these circumstances, unfortunately, your dependent cannot continue with you on a skilled worker visa route. No matter if your dependent is already living with you in the UK on a graduate visa or on a study visa, still if you get a job after 22nd of July 2025 which is classified as a medium skilled, your dependent cannot continue. The only exceptional circumstances for this is like if your dependent or your job that you had which was classified as a which is now classified as a medium skilled, but you had a sponsorship for that particular job before 22nd of July 2025. So I'll take an example of a job role which is office manager. So if you have a sponsorship for an office manager before 22nd of July 2025, then your dependents can still continue provided that the new sponsorship you take, no matter if you have changed the employer, that's absolutely fine. But if your job code remains the same, then your dependent can continue. But if your job code changes, so previously, let's suppose you have a sponsorship for an office manager before 22nd of July. And after 22nd of July, now you have a sponsorship for a care worker. So in these circumstances, the dependent cannot continue because your job code has been changed. You are not on the same job route that you were before. Furthermore, what people get confused about is regarding their children born in the UK. So the question I do get a lot nowadays is that whether if a child is born in the UK, that child can continue as a dependent on their parents' skilled worker leave to remain. So what the immigration rules, what the UK immigration rules say about children born in the UK and for them to be added as a dependent on their parents' skilled worker leave to remain. So there are two situations in this. Number one thing is that first of all, what the immigration rules say that both the parents should have a valid leave to remain in the UK. So if one parent, the main applicant, is having a sponsorship as a skilled worker, the other parent, father or mother, even though if they have a leave to remain in the UK as a graduate visa, on a graduate visa or on a study visa, still in these circumstances, if the child is born in the UK, the child can continue to be, the child can be added as a dependent on the skilled worker visa route. It's not necessary that both the parents should have a skilled worker visa sponsorship, or one should have the lead main applicant should have a skilled worker visa sponsorship and the other parent should be dependent on the main applicant. That's absolutely not the case. What the immigration rules say that both the parents should have valid leave to remain, valid permission to remain in the UK, and in such circumstances the child can be added as a dependent. Furthermore, if both the parents have sponsorship for a medium skilled role, well, again, both if that doesn't matter at all, because in these circumstances as well, both the parents will have valid leave to remain in the UK, so the child can add it as a dependent. The last thing over here is that under the immigration rules for rules relating to children to be added as dependent on skilled workers, if let's suppose one parent has a sponsorship for a job role which is classified as a medium skilled or higher skilled, the other parent who is overstay or has no valid leave to remain in the UK, in these circumstances what the Home Office normally says is that they normally decide to refuse the application, but still the immigration rules say that there are certain exceptional or compelling circumstances which the Home Office should take into account. So if the Home Office, the caseworker who is deciding your application, considers that if the application is refused, that won't be in the interest of justice. So even though if the one parent is an overstayer or without any valid leave to remain, the decision maker can still exercise discretion over here and subsequently grant leave to remain to the dependent child. So if you are concerned about your child's or your dependent's immigration status in the UK and you are confused about your skilled worker visa route and whether your dependent can continue with you or not, then all you need to do is just contact out the number that you can see on your screen, and let's discuss your case together and let us take care of the complex immigration matter. Thank you very much.